When state banking commenced in Australia in the early 20th century, one purpose was to encourage saving among ordinary working people. Governments did not want to undermine the private banking system, which already operated to bring large amounts of capital into Australia from the United Kingdom. One strategy to meet these two objectives was limiting the payment of interest to the first £1,000 in an account. This was much more than most workers would ever save. A basic wage back then was about £4 a week. However, it deterred those with substantial financial resources from moving their money into state banks. Edwin Joliffe had £1,000 in the Queensland Government Savings Bank. He wanted more government interest, so he put £900 into an account in his wife's name, with himself as the trustee. She unfortunately died, and the state government wanted to levy death duties on the money in the account because that account belonged to her. Joliffe objected, disclosing that he never intended to establish a trust, that it was a scheme to obtain more interest. A lower court found as a fact that this was his intention. In the High Court, the majority felt bound by that finding, and so because there was no intention to create a trust, one of the three certainties for trust formation was missing, and there was no trust. Justice Isaacs, however, made a strong dissent. He said that once there had been an express declaration of an intention to create a trust, that could not be walked back by the settlor later claiming that they had secretly not intended to create a trust at all. He said, "In the present case, looking at the documents by the light of the relevant law and the directions of the bank and the uncontroverted circumstances, there appears to me to be a distinct declaration by Joliffe that he deposited and held the deposit in trust for his wife. The declaration has been made without mistake as to the nature of the act done, and in my opinion it is not open to Joliffe to affect the result by subsequent evidence of his then undisclosed intention, contrary to the unambiguous declaration he made." This case ultimately tells us that to satisfy the certainty of intention to create a trust, we should look at all the circumstances and not merely at the evidence of the settlor.